So good evening, everybody. I'm going to speak for a very short period of time. For those of you who don't know me, my name is Louise Galliffer, and I'm Chair of the Cambridge Faculty of Law. So it's my great pleasure to welcome you here this evening for one of the most important annual lectures given at the faculty. As many of you will know, the Sir David Williams Lecture has been an annual event since 2001, and it is delivered in honour of the late Sir David Williams. He was Rouse Professor of English Law. I think we have a couple of us here, David. So I am now Rouse Professor. David Veltman is one of my predecessors, and Sir David Williams is one of my scarily eminent predecessors. And then after that, he was a Vice-Chancellor of Cambridge University. He is one of the most distinguished professors that's ever been in this faculty, I think, and in recognition of that, this building in which we are was named after him in 2016. Now, we're very honoured today indeed to have Lady Sally Williams and her family. Lady Sally is David's widow, so it's lovely to have you all here, and very, very welcome to you. We're also very, very pleased that Michael and Jean Russ, who are over there, are able to join us today. They have very generously supported this lecture for many years, and I would like to thank them publicly for their great generosity. Thank you very much indeed for that. We have as well other distinguished guests and, of course, our distinguished speaker, but I'm going to hand over to Kirsty Hughes, who will introduce our speaker. I'd just like to also thank publicly Kirsty for all her organisation of this excellent event. Thank you very much, Kirsty.
I'm Kirsty Hughes. I'm the Director of the Centre for Public Law, and it is a great pleasure and a privilege to welcome our speaker tonight. As Louise indicated, this lecture series is named in honour of Sir David Williams, and we are delighted to have his family here today, Lady Sally Williams, his children Rhys, Sean and Rhiannon, and his grandson Griff. Sir David was a highly distinguished legal scholar, producing landmark works on official secrets, public order, civil liberties, and public law. He was president of Wolfson College and Vice-Chancellor of this university. He has an enduring legacy for his many endeavours and the values that he brought to them. And it's in this spirit that the lecture series was generously founded by John Nolan and Michael Russ. And on behalf of CPL, I would also like to echo the thanks to Michael and his wife, Jean, and we're very pleased that you're here with us this evening. The first lecture was given in 2001 by Sandra Day O'Connor, the first female Associate Justice of the US Supreme Court. At the time, she observed that she was certain the Sir David Williams lecture series would live long and would prosper, and how right she was. Since 2001, the annual Sir David Williams lecture has been given by a rich array of speakers. In addition to eminent practitioners and academics, there have been a number of senior members of the judiciary. And this is when I represent the different jurisdictions. From the UK, we had Lord Bingham, the Right Honourable Lord Justice Laws, Sir Stephen Sedley, Sir Rabinder Singh, and Lady Brenda Hale. From the European Court of Human Rights, former President John Paul Costa. From Canada, the Right Honourable Beverly McLaughlin. From the United States, the Right Honourable Ruth Bader Ginsburg and Chief Justice John Roberts. From South Africa, the Mr. Justice Chaskslin and former Justice Kate O'Regan. From New Zealand, Sir Kenneth Keith and Dame Sian Elias. Which of course brings me to our speaker, the former Honourable Chief Justice Susan Kiefel of the High Court of Australia. Susan Kiefel was born in Cairns, Australia, educated in Queensland, and here at the University of Cambridge at Wolfson College, where she received an LLM and first met Sir David Williams and Lady Sally Williams. Having been admitted to the Queensland Bar in 1975, in 1987 she became the first woman in Queensland to be appointed Queen's Counsel. She became a Justice of the Supreme Court of Queensland in 1993 and a Justice of the Federal Court in 1994. For 4 years, she served as a part-time commissioner of the Australian Law Reform Commission. In 2008, she was made an honorary fellow of Wolfson College and in 2011, she was awarded the Companion in the General Division of the Order of Australia. Susan Kiefel was appointed Chief Justice of the High Court of Australia in 2017, having served as a Justice of the High Court since 2007. It is a great pleasure and an honour to welcome her back to Cambridge this evening and to hear her lecture entitled Judicial Review of Discretionary Decision-Making, Differences of Approach. Thank you.
Thank you, Kirsty, and may I also add my thanks to you for all of your assistance to both myself and to my staff in preparation for this occasion. To the Williams family, and Lady Williams in particular, who is well known to us and a dear friend, the Chair and other members of the Faculty of Law, distinguished guests and students. It is an honour to be invited to give the Sir David Williams Lecture this year. I was a member of the audience in 2001 when the Honourable Justice Sandra Day O'Connor gave the inaugural lecture in the presence of Sir David. The lecture continues to be held annually in his memory. Sir David is remembered for his considerable contribution to scholarship in the area of public law and for the roles he undertook at university colleges and for the university itself as its Vice-Chancellor. He was also a remarkable teacher. Many LLM students attended Sir David's lectures on judicial review of administrative action over the years. That group included me. I think I speak for all of us when I say that it was a privilege to be taught by him. I believe Sir David and Lady Williams had a special fondness for Australia. Earlier in his academic career, they spent a year there when he lectured at the University of Adelaide. I am told that later he came close to joining the Legal Academy in Australia, but Cambridge was to prevail, and he was made the Rouse Professor of English Law later. He and Lady Williams nevertheless maintained a strong connection to Australia and visited many times. The connection was maintained through the many friendships that he forged within the Academy, with judges and with former students and members of his colleges. He was invited to speak about public law, including to judges. Such was the esteem in which he was held. These friendships and interactions were not confined to Australia. David Williams was president of Wolfson College in the mid-1980s, when my then future husband Michael and I applied to and were accepted for study in Cambridge. For both of us, he played an important role in that process. He had previously been a fellow and reader in public law at Emmanuel College. His leadership of Wolfson was both dynamic and practical. His vision for the college involved it taking postgraduate students from many countries, including those of the Commonwealth. He was held in high regard and with great affection by students and staff alike. One of the most important roles undertaken by the courts of the United Kingdom and Australia, and the courts of other common law countries, is the review of decisions of executive and administrative decision-makers which affect those who are the subject of the decision. In undertaking judicial review, the concern of the courts is that the power given by a statute to make the decision in question is exercised lawfully. If it is not, the decision may be liable to be set aside by the courts. The role of the courts in judicial review is a strictly judicial one. In what was an uncontroversial statement in the Wednesbury case, to which I shall later refer, it was explained that the courts can only interfere with an act of executive authority if it be shown that the authority has contravened the law. The law here referred to is both the statutory law from which the decision-making power is drawn and the common law developed by the courts. Statutes conferring decision-making power often give the decision-maker a discretion which allows for choices to be made about the decision or conditions which might be attached to it. The discretion may be expressed in very wide terms. Even so, such a discretion has never been regarded by the courts of the United Kingdom and Australia as completely at large or unlimited. The courts have insisted that a discretion be exercised reasonably in order for a decision to be lawful. But to state that requirement of reasonableness does not explain what the common law means by it and by what means reasonableness is to be tested. In the mid-20th century, the Wednesbury test, so called, restricted the requirement of reasonableness to one of rationality. It was some time before this view was questioned, notably by courts of the United Kingdom. By the late 1980s, the Wednesbury test came to be considered as unduly restrictive when a fundamental human or other right was affected by a discretionary decision. The UK courts came to apply differing levels of scrutiny of the decision, which had regard to the nature of the right, and applied a test similar to that of European proportionality analysis to determine the reasonableness of the decision. Australian courts did not take that path. Although reasonableness in decision-making may now be said to require more than mere rationality and to be capable of being tested by drawing inferences from the outcome of the decision under review, the lawfulness of discretionary decision-making remains in Australia largely tethered to the question whether the exercise of the discretion is within the aim or purpose of the statute which gives the discretion. There is, though, also a question, perhaps not yet fully explored, as to the nature and extent of this inquiry. It is not my purpose to suggest that either approach as to how discretionary decision-making is to be tested is to be preferred. Rather, it is to suggest that we should acknowledge the differences of approach which have developed and attempt to identify what might explain those differences. What influences have the courts of either country been subject to in developing their jurisprudence? What are the respective frameworks within which judicial decisions of this kind are made? At the least, such an inquiry, which is of a comparative kind, may better inform our understanding of the present position in each legal system. The common law has for a very long time recognised and enforced limits on the exercise by decision-makers of discretionary powers. In the late 16th century, in Rook's case, the commissioners of sewers had the power to impose or apportion the cost of maintaining sewers, which included embankments and watercourses. In the decision under review, the commissioners imposed the cost of repairing the riverbank on the riparian owners alone, although others involved in agriculture nearby also benefited from the works. It was held that the commissioners' discretion had miscarried. Sir Edward Coke said that regardless of the wide, seemingly unconfined authority given by the statute, the decision of the commissioners, quote, ought to be limited and bound within the rule of reason and law. This view was taken up in the late 19th century in Sharp and Wakefield, where Lord Halsbury equated the exercise of a discretion according to the rules of reason and justice with the exercise of a discretion according to law. Its exercise, he said, is to be lawful and regular, not arbitrary, vague and fanciful. The discretion must be exercised within the limit to which an honest man competent to the discharge of his office ought to confine himself. A proper process of administrative decision-making must take as its starting point the statute which gives the power to make the decision, its purpose and its requirements, express and implied. A decision which is not consistent with or fails to have regard to the statute's aim or purpose, which fails to take into account a consideration which the statute requires to be taken into account, or has regard to a consideration irrelevant to it, is wrong at law. In some circumstances, a failure of these kinds may also make the decision unreasonable, but this may be put to one side for present purposes. Discretionary administrative decisions often involve the making of choices. The term reason applied to that thought process may be understood to refer to a quality which effects a limit on administrative power. The cases I have mentioned provide some examples, such as that the exercise of the discretion must not be arbitrary or capricious. They notably do not include the adjective fair, a term which courts are generally reluctant to use, because it is something about which minds may reasonably differ, and therefore too uncertain for the law in a context such as this. The cases mentioned otherwise leave open the question of what content the common law gives to the requirement of reason, which is to be applied in discretionary decision-making. The question was the subject of consideration in the Wednesbury case. Its full title, Associated Provincial Picture Houses Limited against Wednesbury Corporation, which was decided by the Court of Appeal in 1947. The decision under review was that of the local authority, the Wednesbury Corporation, which was an exercise of a power under the Sunday Entertainments Act of 1932. Prior to that act, it had not been possible for entertainments to take place on a Sunday. The Act allowed local authorities, in effect, to lift that ban. They were given the power to grant permission to venues like cinemas to open on Sundays. The power to do so was expressed very, very broadly in terms which allowed the local authority to impose, quote, such conditions as the authority thinks fit to impose. The condition which was imposed by the local authority was that cinemas could not permit the attendance of children under the age of 15. One obvious practical effect of such a condition was that many families could not attend cinemas. It was argued unsuccessfully for the cinema that it could not have been the intention of the Act to leave the conditions to be imposed at large. It must have at least been intended that any condition imposed be reasonable. No reasonable authority could have imposed such a condition. The exclusion of children, even if accompanied by a parent or parents, was unreasonable, if not also beyond the power granted by the statute. The court's decision did not pay much regard to the statute under which the decision was made or its purpose. Lord Green, Master of the Rolls, identified as an eligible reason the well-being and the physical and moral health of children as being a proper explanation for the decision. His principal concern was clearly not to arrogate the statutory discretion in question to the courts. He drew a firm line between the role of the courts and that of the decision-maker, and said that the courts must exercise restraint in its review of the decision. The discretion was also viewed as so wide as to be almost absolute. As such, the court held that there were only a very few legal principles which could effectively limit it. The court put to one side the circumstances where a decision-maker acted unreasonably by failing to take into account a mandatory consideration or taking into account an irrelevant consideration, and focused on what has come to be called Wednesbury unreasonableness. According to this standard, a decision would be unreasonable in the eyes of the law if it was so unreasonable that no reasonable authority could ever have come to it. The decision therefore effectively limited the common law standard of reasonableness in discretionary decision-making to irrationality, and it did so to avoid the court assuming the role of decision-maker. There was a change of approach in the United Kingdom. In the decades which followed the decision, little attention appears to have been initially directed by the courts of the United Kingdom to the standard of unreasonableness stated in Wednesbury. This may be because it posed such a high standard for review that it was rarely invoked. There was a rare finding of Wednesbury unreasonableness in Wheeler and Leicester City Council. There the council passed a resolution banning a rugby club from using a city recreation ground for a period of time because 3 members of the club participated in a national playing tour of South Africa, which happened to be contrary to the council's policy on apartheid. When the standard was stated in this and other decisions of the courts, it was sometimes reformulated into equally demanding terms such as so wrong that no reasonable person could sensibly take that view, so outrageous in its defiance of logic or of accepted moral standards that no sensible person who had applied his mind to the question to be decided could have arrived at it, and so absurd that the decision-maker must have taken leave of his senses. But by the late 1980s, signs were emerging that the standard was considered to be unrealistically high and should be relaxed, at least in particular categories of cases. The signs were apparent from 2 cases, which I shall shorten to ex parte bug decay and ex parte brind. Both cases involved administrative decisions which affected a fundamental right. In one case, the relevant right was recognised by the Refugees Convention. In the other, it was recognised by the European Convention on Human Rights. At that time, as they are now, breaches of rights under the European Convention were dealt with by the European Court of Human Rights. Whether an administrative decision infringed the Convention, such as to warrant it being held invalid, was determined by that court's application of proportionality analysis. Such analysis required that the decision be connected to a legitimate statutory object, that it go no further than was reasonably necessary to achieve that object, and that its ends were proportionate to the importance of the public interest involved. The tests, Prussian in origin, were also applied in decisions of the European Court of Justice. But at the time of the 2 decisions just mentioned, the Convention did not form part of the law of the United Kingdom and would not do so until the coming into effect of the Human Rights Act in 1998. The courts of the United Kingdom therefore could not approach the question of the lawfulness of a discretionary decision in the same way as the European Court of Human Rights. The 1987 decision of bug decay involved a claim to refugee status. It concerned the adequacy of the consideration given by the Home Secretary to the danger that if the applicant was deported to Kenya, he might be removed from there to Uganda, where he claimed to face persecution. Although the decision actually turned on the need to take account of Kenya's record in implementing the Refugees Convention, the circumstances of the case prompted Lord Bridge to propose that the courts should increase the rigour of the scrutiny for factual decisions which carry particularly serious consequences. He said that within the limitations of the Wednesbury Review, the court must be entitled to subject an administrative decision to a more rigorous examination according to the gravity of the issue. There, what was involved was the most fundamental of human rights, the right to life. Where an individual's life was at risk, the basis for the administrative decision must call for the most anxious scrutiny. Brind concerned directives issued by the Home Secretary to broadcasters, preventing them from broadcasting any matter consisting of words spoken by persons who represented prescribed terrorist organisations. For the reasons earlier explained, Article 10 of the European Convention, which protected freedom of speech, could not at that time be used in English law to require that statutory directives be exercised in conformity with it. But as Lord Bridge again explained, this did not mean that the courts were powerless to prevent the exercise by the executive of apparently unlimited discretions in a way which infringes fundamental rights. Any restriction of the right of freedom of expression must be justified, and this required there to be an important competing public interest. Although the directive was found to be justified by reason of its correspondence with the particular statutory purpose, it was observed that lack of proportionality, the European test in effect, may qualify as Wednesbury unreasonableness. The threads of reasoning in these cases were drawn together in Ex parte Smith, which involved a policy of the Ministry of Defence to discharge personnel of homosexual orientation. Although the Court of Appeal did not consider itself in a position to find the policy to be irrational, it stated the proposition that the more substantial the interference with human rights, the more the court will require by way of justification before it is satisfied that the decision is reasonable. This introduced a more calibrated technique of judicial review. In Daly's case, Daly and Secretary of State for the Home Department, the House of Lords endorsed the test explained in Smith. By this time, the European Convention had become part of the law of the United Kingdom, but Daly did not involve a human right. It concerned legal professional privilege and a policy which involved infringement of prisoners' rights to maintain that confidentiality. Nevertheless, this was a fundamental common law right, and as such was held to attract strict scrutiny. It was held that the infringement of the right was greater than was necessary to serve the legitimate public objective of discipline and control. This is the language of proportionality analysis, as the discussion in Daly confirms. The result of these developments was to allow for a sliding scale of reasonableness review of decisions which involve fundamental rights, whether human rights or rights recognised by the common law, the intensity of which review depends on the nature or gravity of what is at stake. It may now be that, more simply, review will correspond to the perceived importance of the legal right at stake. In Daly, a three-stage test of proportionality similar to the European test was stated. Later, in Pham against Secretary of State for the Home Department, Lord Reid identified counterparts to proportionality as the analysis applied in review of unreasonableness, but observed that this does not mean that the Wednesbury test, as applied by anxious or heightened scrutiny, is the same as the principle of proportionality. In Daly, it had been accepted that there was a material difference between the two principles, and in Brind, the court declined to accept proportionality as a distinct head of review. Nevertheless, as in European proportionality analysis, a margin of discretion was maintained for the original decision-maker. So much is evident from the decision in Smith and by statements in more recent cases. In Pham, Lord Sumption explained that the court's assessment of rational decisions must depend in part on the extent to which the court is competent to reassess the balance which the decision-maker was called on to make. I turn then to the Australian approach. The three-stage European test for proportionality is not unknown to Australian law, but it has only been applied in a constitutional context with respect to the freedom of communication on matters of politics and governance. The freedom is considered to be both implied in and guaranteed by the Australian Constitution. As the term freedom suggests, it does not have the status of a personal right. It is understood as a freedom in a more general sense, but nevertheless operates as a substantial limitation on legislative power. Proportionality is used as a means of analysis, rather than as a principle, to determine whether legislation unduly limits or burdens the freedom and is for that reason invalid. But it has not found its way into the area of my discussion. The Australian Constitution was not written as a charter of citizens' rights. Australia does not have a Human Rights Act, although some states do. Federal law has not involved any concept of proportionality in judicial review to test reasonableness of the exercise of a statutory discretion, including where a human right is affected. Interferences with fundamental common law rights are taken account of as a matter of statutory interpretation. Where the exercise of a discretion interferes with a common law right, Australian law does not necessarily regard this as a question of reasonableness, but rather whether the discretion was truly authorised. The principle of legality requires that any intended interference must be expressed in the clearest possible terms to be effective. This principle is also applied in the United Kingdom and was referred to by Lord Bingham in Daly. Long before Australian courts articulated Wednesbury unreasonableness as a ground of judicial review, it was made clear that every administrative discretion is limited by the subject matter and purpose from which it is derived. Such an approach had been confirmed in a case decided in June 1947. Wednesbury was decided in November of that year. Such an approach did not put Australia at odds with that of the United Kingdom. Statutory purpose, as marking the limits of decision-making power, was well accepted in both systems, but it remains steadfastly the guiding principle in Australian judicial review of statutory discretions. In the judgment of Justice Dixon in 1963 in Klein and Domus, it is evident that the approach to be taken was to look both first and foremost to the statute providing the discretion and its purpose. He said, "This court has in many and diverse connections dealt with discretions which are given by legislation to bodies, sometimes judicial, sometimes administrative, without defining the grounds on which the discretion is to be exercised. We have invariably said that wherever the legislature has given a discretion of that kind, you must look at the scope and purpose of the provision and at what is its real object." Wednesbury unreasonableness also did not receive much attention in Australia for some time and appears to have been rarely applied. It was spoken of in passing in a case in 1949 and applied by one justice in a case in 1972, which had some similarity to the circumstances of Rooke's case. However, it was stated as a ground of review in the Administrative Decisions Judicial Review Act 1977 Commonwealth, which referred to a decision or conduct being subject to review as being one so unreasonable that no reasonable person could have so exercised it. Wednesbury unreasonableness was not endorsed by the High Court until 1986 in Minister for Aboriginal Affairs and Pico Wallsend. It and the subsequent case of Attorney General of New South Wales and Quinn adopted the Wednesbury test and its focus on who is the repository of the statutory discretion. These cases have never been challenged or doubted. In Pico Wallsend, the Minister recommended that land should be granted to its traditional owners on the basis of a report which omitted information which was subsequently supplied. The circumstances were held to be such as to require the Minister to take account of the new material as part of the duty to take account of relevant considerations, and also as part of the duty to make a decision in light of the actual facts disclosed by the material in his possession. In connection with the unreasonableness ground of judicial review, Justice Mason said that the limited role of a court reviewing the decision, the exercise of an administrative discretion, must constantly be borne in mind. He went on, "It is not the function of the court to substitute its own decision for that of the administrator. In the absence of any statutory indication of the weight to be given to various considerations, it is generally for the decision-maker and not the court to determine the appropriate weight to be given to the matters which are required to be taken into account." This approach was subsequently confirmed in Quinn, where it was said that the merits of administrative action, to the extent that they can be distinguished from legality, are for the repository of the relevant power and subject to political control for the repository alone. That Wednesbury unreasonableness required something approaching irrationality in decision-making was evident from its application by the High Court in Chan and Minister for Immigration. There the applicant claimed to be a refugee. The minister's delegate found that he did not have a well-founded fear of persecution by reason of his political opinion, despite also finding that he did have a fear of persecution and had experienced discrimination on the basis of his membership of a family known for having anti-revolutionary views. Somewhat irrational. It was held that the delegate misconceived the notion of persecution and irrationality and treated the appellant's association with anti-revolutionary views as having nothing to do with political opinion. The legal standard of unreasonableness for review was considered more recently by the High Court in Minister for Immigration against Lee. There the applicant sought review of a decision by a tribunal refusing her a skilled residence visa. Following a hearing by the tribunal, the applicant requested it delay its decision to enable her to obtain a further skills assessment based on genuine information. She had previously provided materials which were not so based. The tribunal had a statutory discretion to adjourn the review from time to time, but refused the applicant's request to do so on the basis that it was not prepared to delay any further, and affirmed the delegate's decision. The refusal to adjourn was held to be unreasonable. There is some basis for thinking that there was some widening of the stringent approach of Wednesbury, at least in the joint judgment in Lee. It was there said that Wednesbury is neither the starting point nor the end point for the standard of unreasonableness. That standard should not be regarded as limited to an irrational, if not a bizarre, decision. And it was added that unreasonableness could be inferred in some cases, as it is sometimes in cases involving review of a judicial exercise of discretion. The latter idea means an appellate court may infer that in some way there has been a failure properly to exercise of a discretion if upon the facts the result is plainly unjust. Addressing the submission that the tribunal may have thought that enough is enough in terms of the process afforded to the applicant up to the point of her request for delay, it was said that it was not apparent how such a conclusion could be reached, having regard to the facts and the statutory purpose to which the discretion to adjourn is directed, namely, to provide an applicant for review the opportunity to present their case on the questions in issue. It may be observed that statutory purpose was not used as determinative of the question of the lawfulness of the discretionary decision. Rather, it was used to inform the question of reasonableness. In the joint judgment, it was stated that unreasonableness is a conclusion which may be applied to a decision which lacks an evident and intelligible justification, a view which has been repeated subsequently. The reference to a decision requiring an intelligible justification may to an extent be thought to impart notions of proportionality. Indeed, it was accepted in Lee that theoretically an obviously disproportionate response, one by which more weight than is reasonably necessary, having regard to the statutory purpose, is one path by which a conclusion of unreasonableness might be reached. But it was also observed that that proposition had not been the subject of argument on the appeal, and it has not been raised since. Whatever expansion of the standard of unreasonableness can be found in Lee, the decision did not involve any recognition that the review would differ according to the rights in question. There is absent from the Australian approach any suggestion of a sliding scale of review. Moreover, the decision in Lee did not involve any reconsideration of the earlier decisions of the court in Pico, Walton and Quinn. The court made it clear that the standard of legal unreasonableness does not involve substituting a court's view as to how a discretion should be reviewed. Whether a test similar to proportionality analysis does involve replacement of the administrative decision may be put to one side for present purposes. It has not been the subject of consideration by the High Court. What remains clear is that there remains a reluctance to enter upon the field of the discretion. Some observations on the differences of approach. The standard of Wednesbury unreasonableness had been subjected to considerable criticism in the United Kingdom by both the Academy and the courts for some time before it was revisited. In Daly, Lord Cook described Wednesbury as an unfortunately retrogressive decision in English administrative law. In Australia, there has been strong criticism from some academic lawyers, but less so from the judiciary. And as has been seen, the approaches of the courts of the two legal systems to the Wednesbury standard and the review of discretionary decision-making more generally has been markedly different. The approach to judicial review of discretionary decision-making is not the only area of divergence which has taken place between Australian and United Kingdom courts with respect to administrative law, particularly since the 1990s. It is a simple enough matter to point to the United Kingdom's relationship with Europe, its conventions and rights-based jurisprudence, as well as the coming into effect of the Human Rights Act, as influential in the sphere of administrative law. This would include the approach to legal unreasonableness. But one might think that there must be other factors at play, such as the constitutional framework within which the courts operate and the perceptions gleaned from it as to the role of the courts. Australian administrative law has a strong constitutional dimension. Australian courts have largely developed their approach to judicial review by reference to the framework provided by its constitution. As earlier mentioned, Australia's constitution was not written with a view to the protection of individual rights. Neither it nor any Commonwealth statute contains reference to human rights. Such protection was left to the common law, upon which the Constitution is based, but to which it is also subject. The unwritten British Constitution may not be understood to be so limiting, and the Human Rights Act has put the role of the courts here beyond doubt. The Australian Constitution provides for a separation of powers, most relevantly, for a separation of judicial from legislative and executive power. It does so by requiring that certain courts only exercise judicial power and that the legislature and the executive cannot. This may be thought to be a stricter separation of powers than that provided by the unwritten British Constitution. This strictness about the separate roles of the courts and the other branches of government may explain the strong dichotomy viewed between legality and merits in administrative law. Professor Cheryl Saunders has observed that, quote, Australian doctrine limits the appropriate scope of judicial review by drawing a sharp distinction between questions of lawfulness on the one hand and questions of merit on the other, merit being understood to encompass considerations of policy, fact, and the exercise of discretion within parameters. This distinction is in turn explained by the roles the High Court of Australia has historically seen for the courts and for administrative decision-makers. That view both precedes and coincides with that expressed in Wednesbury. As noted earlier, in the leading case of Pico Wallsend, Justice Mason cautioned that it is not the function of the court to substitute its decision for that of the administrator by exercising a discretion which the legislature has vested in the administrator. Australian case law shows that the High Court has strongly sought to defend the separate role for the judiciary provided by the Constitution. One way of ensuring that it is not encroached upon is to be seen to recognise the roles of the other branches of government and not to trespass upon them. Another constitutional difference may be that for Australian courts, the validity of legislation made under constitutional power is always in the background. Courts are attuned to the scope and limits of legislative power. It is almost impossible, where the exercise of a discretion is challenged as going beyond its limits, to ignore, as a starting point, the validity of the legislation in question. In this context, the constitutional role given to the judiciary may once again be relevant. In this regard, one might consider, hypothetically, the approach of Australian courts to the circumstances prevailing in FAM, which involved the deprivation of a person's British and EU citizenship on the ground of national security, with the possibility that the person was rendered stateless. The decision in question was viewed by the court through the lens of the person's rights. The Supreme Court held that the intensity of the scrutiny to be applied was high, given the radical consequences of the decision. An Australian court is likely first to consider whether the law which gave the executive that decision-making power was valid. If revocation of citizenship is seen as a form of punishment for particular conduct or the threat of it, that kind of decision may be considered by Australian courts to be solely a matter for judicial decision. The strictness of approach to the separate role of the courts and the other branches of government, and the resulting dichotomy between the law and merits on judicial review, may largely explain the focus of Australian courts on the statute, where the reasonableness of a discretionary decision made under it is challenged. It may be accepted that the approach in Australia is to view reasonableness through a statutory lens, and in particular, statutory purpose. The use of proportionality-style analysis by the United Kingdom courts does not ignore the purpose of the statute in question. Indeed, it is integral to it, although as a preliminary step in reasoning, as distinct from being determinative of the question of the lawfulness of the decision. There is no suggestion that lack of consistency with statutory purpose is no longer a ground of review in the United Kingdom, but it may be that there is now less focus upon it. It may be added that to state that a review of the exercise of a statutory discretion has regard principally to statutory purpose does not necessarily provide a full picture as to the approach actually taken by Australian courts. More needs to be understood about the identification of purpose in the course of statutory construction and any choices that are open as to what the statutory purpose may require and the limits that it therefore effects on discretionary decision-making. Justice Brennan's remarks in Quinn may be apposite to such a question. He said that the modern development and expansion of the law of judicial review have been achieved by an increasingly sophisticated exposition of implied limitations on the extent or the exercise of statutory power. In conclusion, the courts of the United Kingdom and Australia do share in common a recognition that statutory purpose has a part to play in the review of discretionary decision-making. A question which might be asked is whether Wednesbury could have simply been decided on that basis. On one view, it was an argument the appellant sought to raise. The condition having the effect of limiting cinema audiences might not be thought to be consistent with the statutory purpose of opening entertainment venues to the public on Sundays. At the least, that might accord with a modern approach to statutory construction. And if this had been the approach taken, one wonders how the law relating to reasonableness of the exercise of a discretion may have otherwise developed. Thank you for your kind attention.